This is Bloomberg Law with June Grasso from Bloomberg Radio.
A Texas judge struck down the FTC's ban on non-compete agreements before the ban even went into effect, blocking the agency's effort to make labor markets more competitive. Non-compete agreements have become increasingly common, with an estimated 20% of workers, that's about 30 million Americans, subject to them. Last January, President Joe Biden touted the FTC's overhaul of the rules, saying non-competes make it needlessly difficult for average working Americans to get better jobs.
It's another thing to say you're working for Subway and you can't walk across the street and go to Jimmy John's and get a 20-cent raise. What tells that all about other than keeping wages down?
But Texas Judge Ada Brown, a Trump appointee, said the FTC lacked the authority to enact the non-compete ban and tossed it out. Joining me is William Kovacic, a professor at GW Law School and the former chair of the FTC. The judge said in her 27-page ruling that the FTC's proposed rule was arbitrary and capricious and would cause irreparable harm. Can you tell us more about her decision?
Judge Brown had two grounds for suspending the implementation of the rule, vacating it. The first is the one you mentioned, which is that the FTC lacked an adequate basis to support the scope and the complete reach of the rule. That is, the rule applies to a very broad range of employment contracts. There are a couple of carve-outs, but the judge concluded that you lacked a sufficient evidentiary basis to implement that rule, and therefore the rule itself is arbitrary and capricious. The second basis for rejecting the rule is her conclusion that the FTC lacks the legal authority to adopt rules involving competition policy. That is, substantive competition rules are beyond the FTC's remit. This involved a fairly elaborate and technical analysis of the FTC's authority going back to 1914 when Congress established the FTC Act and coming forward. But her review of the original framework and its subsequent evolution is that the FTC simply lacks legal authority to adopt and apply such a rule, so that on that basis as well, the rule was suspended.
Do you agree with her reasoning?
On the second point, I do. It's always difficult to decide when you have a good fit between the substantive rule and the underlying basis. I think what's a matter of concern is that, first, it's an extraordinarily broad rule, and unashamedly, it applies to the laws of 48 states that currently allow various forms of non-compete. It involves, as the FTC emphasized, hundreds of billions of dollars of wages. There are tremendous economic stakes here. This is very clearly a major extension of the FTC's oversight role in labor-related agreements. You would think that for a measure of that part, you would have to have a fairly extensive and careful review of the existing literature, pro and con. I would say in many ways the FTC took shortcuts on that and tended to brush aside views that it found to be incompatible with its policy preferences. And I think that did create a real vulnerability with respect to the arbitrary and capricious issue. The argument about the FTC's authority is ambiguous. There are certainly plausible arguments that the FTC has the authority. My intuition is that given the current direction of Supreme Court jurisprudence involving the grant of authority to administrative agencies and the effort of administrative agencies, regulators, to interpret their authority in a way to meet new conditions and to stretch, in some sense, the application of their authority, the current Supreme Court is skeptical about that. The current Supreme Court says, if you want to do bold things and to apply the law in a broad way, we want you to anchor that in a clear statement of congressional purpose, that Congress, to allow you to do bold things, has to say so clearly. The direction of travel of this doctrine runs against the philosophy, the interpretation approach that the FTC is relying on here. Goodness knows how the Supreme Court would ultimately evaluate the rule. I haven't talked to them today, so I don't know exactly what they'll do. But my inference from the current direction of their jurisprudence and the attitude that's embedded in that jurisprudence is that this rule would have a very difficult time surviving review as it goes up to the court, and that Judge Brown's ruling here that the commission just doesn't have authority to issue any rules involving competition is quite likely to be sustained.
How about another agency doing this? The National Labor Relations Board's top lawyer is moving ahead with an enforcement strategy to make restrictive covenants illegal. General Counsel Jennifer Abruzzo says such pacts deny workers the ability to quit or change jobs, which in turn interferes with exercising their organizing rights. Do you think a rule by the NLRB would survive?
I'm less familiar, June, with the specific grant of authority that the NLRB would be relying upon. Certainly in the application of its adjudication function, that is in the prosecution of individual cases, it would be less likely to run into the question of whether it has rulemaking authority, which is the issue in the FTC proceedings. The question for the NLRB would be, in its law enforcement capacity, has it appropriately interpreted the mandate that Congress gave it, and would reviewing courts conclude that its interpretation of its law enforcement mission encompasses the concerns that the NLRB Solicitor General has raised about non-compete. So the NLRB might be in a position to challenge these. I don't know if they mean to do it by rulemaking. And I would add that the FTC does have authority to challenge individual non-compete agreements using its law enforcement mandate. It has a law enforcement mandate to prohibit unfair or deceptive acts or practices or unfair methods of competition. That involves case-by-case adjudication to challenge specific arrangements. That authority is not endangered in the challenges that are present in the federal courts now. The FTC can continue to do that. That has the disadvantage that you go step by step and you don't have the capacity necessarily to adopt a broad-based prohibition that applies across the country and condemns all of the arrangements. It's a more laborious way to get to the final destination that you wish to achieve. That path is still open to the FTC. That kind of litigation, I assume, is open to the NLRB. That case-by-case litigation approach is available. The district judge decision in the FTC case deals with the effort in a single rule to achieve what otherwise be attained through a collection of cases over time.
How big a blow do you think this is to the FTC?
I think it's a significant blow. When I look at the whole span of the FTC's program since the Biden administration began in 2021, I would characterize this as the most significant initiative that they pursued. Most significant measured by its purported economic impact, its anticipated economic impact, which is self-described as being very broad. Most significant in terms of its effort to move the doctrinal framework of intervention outward, to gain acceptance for the idea that the FTC has power to issue these competition rules and include powerful prohibitions in them. And third, symbolically, it is held out as an example of the Biden FTC's willing to take more risks, to be far more ambitious than its predecessors are, and as such to bring a new attitude toward the application of federal power to control commerce. In all of these respects, I would say in the entire fleet of FTC initiatives, this is the flagship. And if you are running a Navy, you don't want your flagship to be sunk.
In a statement, FTC spokesperson Victoria Graham said the agency is seriously considering a potential appeal. Do you think they should appeal this? Because it's going to the Fifth Circuit, which is ultra-conservative, has a reputation for overturning Biden administration rules, and then likely to the Supreme Court where, as you mentioned, I don't think they'll find a receptive court.
I think they should. If I was guiding the strategy, I would do it. One reason is that the FTC has had some surprising success over the past year in front of that very court. It was in the context of a merger challenge to an acquisition by Lumina of the Grail Company. It was an appeal from an FTC administrative decision. The parties opposing the FTC raised 4 distinct constitutional and administrative law challenges to the FTC's authority. The court basically brushed aside all of the administrative law and constitutional law challenges. It upheld the FTC's decision, and in a sense, it showed that even in a very difficult litigation environment, you can prevail. So it's not a hopeless pursuit. And another reason I'd bring the case is that I think it would demonstrate the conviction of the agency to take on hard, difficult matters, notwithstanding the possibility of failure in the court. You're ultimately going to have to face a judiciary, perhaps ultimately the Supreme Court, that has raised issues with this form of approach. My suggestion was have it out now, get the appellate decision, take it up to the Supreme Court and say, we need a basic decision about the framework of FTC authority generally and about its application of its asserted authority in this instance. Let's not wait for another case or another time. Let's bring it to a head now, and if the result is adverse, we go back to Congress and say, if you want us to be active in this area, give us a clearer mandate to do so.
There are non-competes at the state level. 4 states have banned nearly all non-competes, and at least 11 more have thresholds protecting lower income, middle income, hourly workers, etc. Do you think we'll see more states passing laws banning non-competes?
I think we'll see an amendment of the legal framework, and this is a respect in which the FTC's initiative, despite the risk that I've been describing, in a sense, has achieved real success. It has drawn broad attention within the United States to the issue of non-compete. It's catalyzed reconsideration of the existing legal framework, which, with the exception of a handful of states such as California, does not prohibit these agreements or render them unenforceable. Most states allow them to be evaluated by a reasonableness standard. The FTC's initiative has inspired a new debate about whether or not these kinds of restrictions are appropriate. So I think we're going to see a rethink in many states that allow these arrangements under a reasonableness standard to rethink that approach, perhaps to create presumptions against them, to apply prohibitions that exist now on certain non-competes more broadly. So we could see in the states a restoration of bolder enforcement and scrutiny regarding non-competes, and I think you point to a result that the FTC probably had in mind in taking a very bold approach here, which was to change the policy debate, to bring about indirect effects, including in the state government.
Thanks for your insights, Bill. That's Professor William Kovacic of GW Law School. Coming up next, why the Supreme Court's workload is backloaded. I'm June Grasso, and you're listening to Bloomberg. You might remember the end of the Supreme Court's term in June when, in the space of a week, the Republican supermajority slashed the power of regulators, curbed the SEC's use of in-house judges, tossed a $6 billion opioid settlement, and allowed cities to evict the homeless from public encampments. And then the justices added a day to issue the blockbuster decision shielding former presidents from criminal prosecution and giving Donald Trump an election year boost. So why do we increasingly see the most controversial decisions handed down the last week of the term? Justice Elena Kagan told a group of judges and lawyers last month that it's not planned that way.
You know, I read at the end of every year all these theories about how we've sort of planned it this way. And, what I would say are sort of a little bit conspiracy theories. And the truth of the matter, truly, this is really, truly the case, is that we announce decisions when they're done.
More and more, the court's workload is bunched up toward the end of the term, and the upcoming term appears to be no exception, as the justices are off to a slow start. Joining me is Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson, who's investigated this. Kimberly, start by explaining how the Supreme Court's calendar works.
Yeah, so the Supreme Court has a pretty long break in the middle of the summer, which I think a lot of the justices like. It tends to break up the workload, at least in the past it's broken up the workload. But that means that when the justices come back to start off their terms in October, they really have had to do some work beforehand to sort of have enough cases that have already gone through briefing and that are ready for argument. So it really means that in January, February, March, the justices need to be granting cases for their October, November, and December sittings. The problem with that is that's also when the court is still hearing new cases and trying to get decisions together. So it becomes a really busy time for the justices.
Argument sittings start again in the fall, famously on the first Monday in October. How many cases have they lined up so far?
Well, this term is starting off like many recent terms where the justices are really getting a pretty slow start. A full calendar we think of, full argument calendar is about 2 cases a day where the justices hear cases in the morning at 10 and 11. We haven't really seen that for a few terms. And so instead, the justices are coming in under their full calendar. And that just means that they're going to have to make up those empty argument sittings in the later sittings that they have in January, February, March, April. And, again, that's creating this backlog where right as other work is sort of ramping up, they're having to go back and fill in for the deficit that they had in the fall.
And they're hearing far fewer cases than they did years ago.
Yeah, that's one thing. Even Justice Kagan, she talked about when she clerked many decades ago, the court was hearing, 100 to 150 cases. Now the justices are hearing about 60. So it's been a really dramatic decrease, and it's been a really steady one, too. Now, I started covering the court about a dozen years ago, and the court was hearing about 75 cases, and now it's closer to 60 each year. So it keeps getting smaller and smaller. Nobody really knows why. We know the justices are aware of this, but nobody's really been able to pin down why it is that the court's hearing so fewer cases.
Justice Kagan said that even she doesn't understand why so many cert petitions are being filed in the spring.
One part of it is a little bit unfathomable to me, which is for whatever reason, we seem to get a lot of cert petitions that we take at a time of the year where arguments are scheduled in March and April. And those cases are just not realistically going to come down until the end of June. And in fact, even that it's a very crunched time period.
For some reason, a lot of the really significant petitions seem to be coming into the court sort of in the later months of its term, right when the court is really trying to get out all of its opinions, usually when the justices are circulating opinions on its most sort of consequential cases. And so it just really seems like all the work is sort of bunching up in the later months of the term, which, are in the spring and early summer. And so she didn't really have an explanation for it, but she said, for whatever reason, that just seems to be the case, and it makes for a really, really busy March and April sitting. And then she said something that I thought was really candid, was that, she doesn't think that the justices can really do their best work in those months because there's so much going on. And she sort of told the story of a previous justice talking about, one of his clerks coming to him and saying, I can't make sense of this case. Then he would say, well, when was it decided? Is it an April case? And if it is, then that would explain why the case didn't really make any sense. So Justice Kagan was talking about that seems to still be the case decades on.
Is there anything in the way they're handling cases or agreeing to cases that's changed over the years?
I think one thing that, advocates that I talk to, people who have clerked at the court, people who argue with the court, they say that it seems like the court is taking bigger cases, meaning, these cases that really grapple with big social issues that are really important for the country. And those cases, they're hard cases. They take up a lot of the court's time. They're more likely to be divided cases, which means that there's more likely to be more opinions, more dissents, more concurrences. All that just takes a lot of time.
The number of concurring opinions has really shot up in recent terms.
It has. I think one of the best examples of this from last term was the Second Amendment case Rahimi about whether or not the federal government could bar those with a domestic violence restraining order from owning guns. And there we saw not only a majority and a dissent, but we saw many, I think there were 5 concurrences. And so, in a case that was 8-1, to see 7 different opinions was really striking, but I think it's something that people think is going to be happening more and more as, again, we have these more consequential cases where the justices feel like, they really got to get it right and they got to explain their reasoning.
Yeah, that seemed like they were each explaining their approach to originalism or textualism or
right.
Despite agreeing. Now, you spoke to someone who said that if the court returned to hearing 75 cases or more, the justices would probably pick up the pace?
Yeah, I think the thinking there is that, if the court is taking fewer cases and if a larger majority of those cases are really high profile, that all that's going to suck up a lot of time. And if the court were to go back to a time where it was sort of resolving circuit splits or cases where it really doesn't matter what the outcome is, there really needs to be some sort of rule for lawyers, that they wouldn't spend so much time on these concurring opinions. There wouldn't be so many dissenting opinions, and it wouldn't create the kind of bottlenecks that we sort of are guessing is happening at the court to kind of push everything back. We really saw that this term when the justices, they used to be sort of a hard deadline that they would not go into July, that was sort of a sacred time for them to go off and take a break or to do some sort of teaching assignment. But for the second time in a few terms, they went into July. And we think it's probably because of this effect of having so few cases and such a high portion of them being really high profile.
They have a 4-month vacation, but they have to work during some of that time as well.
Yeah, especially now, this is another thing that Justice Kagan spoke about, as well as Justice Kavanaugh and Justice Thomas were also speaking this summer. And they all said that they feel really busy, and they're granting 60 or so cases, which isn't as many as before, but they feel like they're working just as hard. And that's because even in the summertime, when they typically wouldn't have a lot of work to do, they're sort of inundated with what we've come to know as the shadow docket, these emergency requests. So they're definitely not on, these vacations like they used to have.
Are there any big cases coming up next term so far?
I don't think we really see the kind of high-profile cases that we saw from last term, which was just blockbuster after blockbuster after blockbuster. But there are some big cases. I think the biggest one is probably United States versus Skermeti, which deals with a Tennessee law that is a ban on gender-affirming care for minors. That's going to be a big one and hasn't been set for argument yet. There's also another Second Amendment case that's sort of like the bump stock case from last year, this one dealing with ghost guns. The Biden administration says that if the justices strike down this rule, that it could really undo federal gun regulations because people can just take these kits and sort of circumvent all federal laws. And then there's another, important environmental case. The justices have really been sort of dismantling environmental cases under Democratic presidential administration. So a few big ones, but again, nothing like we saw last term or a couple of terms ago with abortion and affirmative action. But there's still a lot of time to go.
There might be election cases, too, coming up.
Right. I do think, that maybe part of the reason that the court has gotten off to a slow start as well is that they do anticipate that there will be some emergency election cases that will be sort of making their way up to the justices that will require them to really focus on that in a short period of time. And actually, we already see that happening at the court. So it would be reasonable, I think, for them to think that some of those cases are going to come, but of course they don't know what those are going to look like.
And of course, there's a long way to go, even before the first Monday in October. Thanks so much, Kimberly. That's Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson. And turning now to one of those election cases on the shadow docket that the court decided on Thursday, an emergency appeal was filed by Republicans in the swing state of Arizona, and a divided court decided to allow Arizona to enforce a state law that requires residents to provide proof of citizenship to register to vote, but that will only be allowed in state elections, not in federal elections. Here's elections law expert Derek Muller, a professor at Notre Dame Law School.
So it's really 5-4 to allow this provision, this sort of two-track process to play out. So if you can't prove your citizenship, you can still vote in the congressional elections and the presidential elections. You just can't vote in the state elections. But then there was a different majority that was a 6-3 majority that says, no, actually, these other provisions are also going to be stayed. We're not going to have a split system for dealing with presidential elections. We're not going to require those who are unable to prove citizenship to come and vote in person. 3 justices would have allowed all of these provisions to take effect. 6 of them said that those 2 couldn't take effect, but you had a majority allowing one track of this take effect. So the court comes without any reasons on this. It's a very truncated briefing schedule. They're just trying to issue an order that provides some guidance for election administration officials. Whether or not they give reasons in the future is a matter for another day.
What happened to the so-called Purcell principle where the Supreme Court said, we don't make changes too close to an election because it's too confusing for people? I mean, this is very close to an election.
I mean, the problem is, where do you measure when the change happens? So this lawsuit was first filed in 2022. It was in May that a federal court issued an injunction prohibiting any of these provisions from taking effect. Then it goes on appeal to the Ninth Circuit. The Ninth Circuit says, no, one of these provisions can go into effect. The others are going to be stayed. But then there's another court of appeals later that comes on and says, no, we're going to stay all of them. So depending on where you look, right, each court decision is always later than the last one. It's always coming after the fact. So Purcell is guidance to the courts. Don't change the rules too close to the election. But the Supreme Court has to be able to weigh in and say, no, you court changed the rules too close to the election. So we're changing the change, which creates a little bit of difficulty if you're an election administrator. There's no question about it.
That's Professor Derek Muller of Notre Dame Law School. Coming up next, federal charges in the overdose death of actor Matthew Perry. I'm June Grasso, and this is Bloomberg. 10 months after the overdose death of Friends star Matthew Perry, federal prosecutors have charged 5 people, including 2 doctors, in connection with his death. U.S. Attorney Martina Strada said the investigation revealed a broad underground criminal network distributing large amounts of ketamine to Perry and others.
These defendants took advantage of Mr. Perry's addiction issues to enrich themselves. They knew what they were doing was wrong. They knew what they were doing was risking great danger to Mr. Perry, but they did it anyways.
3 of the defendants have already pleaded guilty. One of the doctors, Perry's live-in assistant, and a drug middleman. The case will now focus on the 2 who have pleaded not guilty. Jasveen Sangha, an alleged drug trafficker known as the Ketamine Queen, and Dr. Salvador Plasencia. His attorney says the doctor gave ketamine to Perry, but insists he did not break the law.
He was a patient. He did receive ketamine treatment therapy.
Joining me is healthcare attorney Harry Nelson of Nelson Hardiman. Harry, tell us about ketamine and what it's used for.
It was originally developed as a tranquilizer for veterinarians, for large animals like horses. But it's been used increasingly, for human beings as a sedative. And in the last 25 years or so, there's been a growing body of research that it can be an effective alternative for treatment-resistant depression, meaning when people are not successful in managing clinical depression with the sort of standard, more conventional treatments like SSRIs, serotonin reuptake inhibitors like Prozac, most famously, and also for post-traumatic stress disorders. Those are off-label uses, but those are the widespread uses that have really led to this massive growth in ketamine in the last couple of years.
And Matthew Perry was being treated with ketamine?
Matthew Perry was getting ketamine infusion therapy. And then at some point, one of the doctors who has been arrested here basically started allowing him to self-administer the ketamine. At least that's the allegation. And the self-administration, it appears, may have come in both the form of infusion at home, meaning through like putting it in an intravenous line, or more commonly what we've seen and what's grown in popularity the last few years has been ketamine taken by a troche, which is essentially like a lozenge. And so people basically just suck on a ketamine lozenge and get the same effect metabolized by doing so.
Is the prosecution out to prove a criminal network here?
It's not clear from what we've seen so far how much this was a coordinated criminal network as opposed to various individuals being prosecuted for their own personal violations of the laws. In the case of the doctors, their writing of prescriptions and their instructions and their sort of permissiveness about giving Matthew Perry the drug is leading to one set of charges, similar to, things we've seen with doctors and other celebrities, where essentially there's like a gross negligence because they owed a duty, as opposed to some of the hangers-on and the entourage who are directly violating drug laws by handling controlled substances, which ketamine is, a Schedule III controlled substance, without any authorization to do so. So they're effectively being charged as drug dealers.
So the 2 who have pleaded not guilty are the alleged drug trafficker and one of the doctors who allegedly taught Perry's live-in assistant how to inject the drug and injected it himself as well. Does it seem like prosecutors gave the deals to those who appeared less culpable?
So it's clear that the government was looking for cooperation from some of the people who were considered lower-level participants. It's always the case that the doctors are viewed as the most serious targets, I think in part to send a message to other doctors, because doctors have a unique privilege in terms of their proximity and access and ability to put the drugs in the place where they cause harm and where this tragedy happens. So I think the focus in these cases is consistently to make an example of the doctors, because as we see here, we have these doctors who just completely go outside the requirements of the law, outside the bounds of safe practice, and essentially set up the circumstances in which this death occurred. So that's always going to be the top level goal of prosecutors.
And they have text messages, and I think this helps also to paint the doctors in a bad light, because the doctor who's pleaded not guilty texted the other doctor about how much to charge, and he wrote, "I wonder how much this moron will pay. Let's find out." So they charged him exorbitant amounts, like $12 worth of ketamine. They charged him $2,000.
Look, it doesn't get any worse than that. We hold doctors responsible for following the Hippocratic Oath, right? To take care of patients, to do no harm. And it's a tricky subject. Money and healthcare is inherently a fraught topic because doctors are entitled to make a living. But when you see the kind of naked greed here and the dehumanizing language, how much will this moron pay, where a doctor was so contemptuous of the patient he was responsible for, that he had a duty to, it's really heartbreaking. And I think it shows a level of dehumanization and disregard for responsibility that is not likely to sit well with a jury or a judge, and probably spells not just losing a license, but spending some significant time in custody for this doctor.
Is the cause of death a possible defense? Because the LA County Medical Examiner's Office said that he died of the acute effects of ketamine, but that contributing factors included drowning, coronary artery disease, and the effects of buprenorphine.
Yeah, buprenorphine is a drug that's become the most popular and widespread sort of drug to keep people from craving opioids. It's been used widely after prescription opioids and other kind of opioid addictions. It basically sort of satisfies that craving without getting people high, and it's safe. People don't die from it. But your question raises a really interesting sort of set of possibilities. Matthew Perry was known, I think, widely to be in really poor health as a result of his drug use, which is often the case. So the question is, was that possibly a factor? Maybe this isn't what actually killed him. First of all, when we talk about the doctors and the responsibility that they played, they owed separate duties. So their falling below standards of practice so extremely is a problem for them, irrespective of what happened. But for everybody in this case who's charged, there's a fundamental principle that you learn when you start law school and you take first-year tort, which is that you kind of take the person who's harmed as you find them. So, in law school, there's a classic case of the eggshell skull, right, of a person who has a very thin skull and an accident, someone hitting them on the head, a hit which ordinarily would not have harmed a normal person. It's sort of your bad luck that you chose to hit this person, and none of us knows, what are the vulnerabilities of the people around us. So for all of these people who have been charged, the condition that Matthew Perry was in was a risk that they were taking, and they didn't have to know exactly how bad his physical health was. And it doesn't really matter if his death would have been preventable had he been in better health. It sort of goes out the window.
The doctor who pled not guilty to the charges, his attorney says his client sold ketamine to Perry, but he insists he did not break the law. The attorney said he was a patient. He did receive ketamine treatment therapy.
Right. So this is going to be probably the hardest case. This case still involved a doctor who gave the ketamine for self-administration without monitoring. And part of what happened here is something fundamentally unsafe, i.e. a person taking ketamine and getting into a hot tub where they were susceptible of drowning just because ketamine causes disassociation. You're not sharp, right? We have all these settings where you take over-the-counter medications and the warning on the label says, don't operate machinery, don't get behind the wheel of a car. And so, too, here, you have to wonder what this doctor thought. I can certainly tell you, in advising practices that use ketamine, we consistently advise that people should be monitored to make sure they're not having a negative effect. Ketamine can have dangerous effects, most commonly disassociation and panic attacks. And so we don't know exactly what happened here yet, and I don't know if we ever will, but I think the doctor still bears responsibility for unsafe administration of ketamine and not making sure that it was being used in a setting where there was oversight by a person who was knowledgeable and able to do what needed to be done if something went wrong.
Harry, I'm not clear on why the doctors didn't just give him the ketamine infusion shots themselves and where the drug dealer came into this.
My sense, just from reading this case and looking at the investigation, is that Matthew Perry had a persistent and significant interest in ketamine that went beyond what most doctors who are responsibly prescribing and administering ketamine will do. And so there was this constant pressure. And there are a lot of questions because ketamine has been a relatively new treatment. We are frequently getting questions from all kinds of practices about how many times ketamine can be administered to the same patient, over what period of time. And so my sense is that there was this constant effort to find the drug that looks more and more like the way that people sort of behave around illegal drugs, where someone who's addicted is constantly looking for a source and a supply and not sort of counting on the fact that routine prescribing through physicians and picking up at pharmacies and so on, or administration in doctors' offices is going to take care of it. So I just think there was clearly a pressure, in the way that the ketamine was procured that led to all these different sources. This is not what good healthcare looks like. This is what drug dealing and misuse of drugs looks like. And so I think it's giving us a really troubling picture of how this happened.
I know you had contact with investigators in this case. Why do you think the feds brought this case instead of the state?
We don't often see federal investigations in celebrity deaths, right? So most of the federal investigations involve sort of broader problems of controlled substance distribution on a wider scale. So that this case was unusual in that respect. I think what was happening here is that the media attention led to enormous pressure on the DEA as the agency responsible for controlled substances. And we have not seen a significant number of DEA cases involving ketamine. And I think there was a conscious decision to make an example of the loose practices around ketamine in this case that led to this unusual decision to go so deep on this investigation. It's interesting because one of the other big cases that we've been involved in recently, also involving a federal Department of Justice investigation driven by DEA concerns, was related to websites during the pandemic loosening standards for ADHD meds like Adderall. We were kind of wondering, there had been a number of ketamine telemedicine sites that took off during the pandemic, and a lot of wonder whether the Department of Justice was also going to turn its attention to ketamine, and we did not see that same kind of response. And I almost read this case and the federal resources here as sort of a makeup, in a way, of trying to devote attention to ketamine out of concern that it's being misused and being given out too loosely. So I'm not sure. That's just my personal theory, but I'm sure we'll learn more ahead.
It sounds like a very plausible theory to me. Thanks so much, Harry. That's healthcare attorney Harry Nelson of Nelson Hardiman. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.